Hello and welcome everyone. Welcome to another inventRight.com TV show. Stephen, what's the topic today?
Andrew, I love this topic because everybody thinks you need this one thing to be successful when you have an idea. Everybody believes that I need a patent. If I only had that magical patent. And I want to talk about all the different things about not only patents, but ownership and your creativity. And do you really need a patent? Because sometimes you do, and sometimes you don't. But I don't want people to rush out like I did. I've got this idea, I rush out, I call my attorney, and I start paying for patents when it was too early because of fear. I don't want that to happen.
Well, Steve, all you need is a patent and everything falls into place, right? You just pay for a patent, you're solid. People will beat a path to your door, right?
Well,
am I being sarcastic?
I love that about you. Yeah, because you know what people are thinking. They're thinking, if I just had a patent, how do I get a patent? Do I need a patent? What does a patent cost? How do I do it? They're thinking all those things. And I'm here to tell you, I have a lot of patents. I have 20 patents in my name. And I've even defended my patents in federal court against one of the largest toy companies in the world. I sold my company that had a patent portfolio.
Okay. And so you would think that you would be all about patents.
And I'm not.
You got patents equal success.
I'm not.
Right? Patents don't equal success?
No, they don't. In fact, most ideas, you can license most ideas without any intellectual property patents. Our students do it. I've done it. Because most ideas go in and out of the market so quick that it doesn't need a patent. So,
But there's an option that's not really a patent, but it kind of is.
What's that?
It's called a PPA, or Provisional Patent Application, right?
Yeah.
It's not a patent, is it?
No.
It's not a patent.
But it gives you perceived ownership. And that's what's so important today, everybody that you're listening. It's really about perceived ownership. I don't think you have to own anything. I don't think we actually do own anything.
And why is it perceived ownership? Because when you have a provisional patent application, you can say patent pending. Is that the perception?
Yeah,
okay.
And because that's enough for a company to go, okay, let's pay the guy. Because they don't know if it's going to issue or not. And they really, tell you the truth, they don't care. They say they do, but they don't. But it's really speed to market.
Well, some do, a lot don't. But so you can't make one statement for everything.
No, but the reality is, who wants to go to court? Apple cannot defend itself. Look how big they are. Either can Nike, either can Disney. So why would anybody think we can? And they've got lots of attorneys, lots of money, and they don't want to go to court either.
Then, Stephen, why don't they just take my ideas? If I can just file a provisional patent, gives me a year, say patent pending. Well, if Apple can, Nike can't, then why?
They do it because they need ideas. Open
innovation.
No,
but why don't they just take my idea?
Why? Because they need more. If they took yours, pretty soon everybody that's a product developer / inventor is going to know about it. And then the door closes up tight. That's the reason why.
It's liability too. I mean, it's a legal liability.
Well, let's say they take your idea and you do get the patent. Well, then you got to, if it's hopefully it's a big success. I tell everybody, oh yeah, hopefully they take your idea, it's a huge success, and you get your patent. Oh no, that's terrible. That's like you hit the lottery.
But Stephen, this is the reality. I mean, and it's just it's statistics. And so we've had students in 40 countries, 12 years, long time, and none of our students have came back to us and said we got knocked off. And now it'll happen one day. It's just a numbers game, but it's the exception. It's not the rule.
No, it's this. You hear stories, right? And I call it workarounds. I don't call it knocked off or whatever. You give a company a reason to work around you, right? And what that means is that maybe they like your idea, but maybe you're being unreasonable. God, inventors, God forbid that are unreasonable. Maybe they ask for too much money up front, or maybe they have this big ego that they want all this money. The bottom line is...
We had a student do that the other day, Stephen. In all our training, we say, don't ask for all this upfront money. And a student came back to us and said, I have interest from the company, and I asked for $100,000, and they got all pissed off at me. And Steve's like, what are they thinking? In every training we've ever done, it says don't do that. And we don't get that very often, but inventors do mess things up sometimes.
Well, Yeah, it happens. It's called
get the money on the back end.
He was top loading the deal.
Right.
And by top loading a deal, licensing is about pay as you go. That's why it's very attractive. But when you front load the deal, you're not making it. You're giving them a reason to work around your idea. Oh, gee, what a thought!
Steve, they got lots of money. Why not just pay me all the money up front and I'll sell it outright, right?
No. The bigger the company, the more successful the company, the less likely to give you a lot of money. Okay, so
it's not going to happen.
I know. So, but the bottom line is, you need to understand about provisional patent applications. You need to understand about patents. They're great tools, but they're not everything. They're a part of it. They're just one small part. So don't let fear drive you to get a patent. Don't let fear from an attorney telling you someone's going to steal your idea to pay for a patent. Educate yourself, right? That's what this video is all about. I have a lot of patents, but I don't necessarily believe in half the ideas I've licensed, which I've licensed lots, don't have patents at all. And most ideas on the market don't have patents. So don't be fooled by that false sense of security of a patent. Educate yourself.
And quite often when you're filing a provisional, you may have very weak or non-existent coverage, but you can still file that provisional and have that perceived protection and say patent pending. And if there's interest from the company, you convince them to pay for the patent. So it's $65 out of your pocket. Isn't that a lot better than spending $12,000 on a patent or God knows how much? Oh my God, you'll always have the bandwidth to move on to the next idea. You'll never run out of money.
And I wonder why patent attorneys don't like to tell people that.
They hate provisional.
They hate us.
They don't. Yeah, okay. They don't like it.
No, but the bottom line is, I think you need to understand the process. I think you need to understand where your strengths are. We're small. We're fast. We can file provisional patent applications. We can use the tools at the USPTO. We can get these companies to pay us with perceived ownership because it's speed to market. They just want ideas, guys. Don't get caught up. Now, that doesn't mean you shouldn't file them, because some ideas are big ideas. And if they are, it takes a different strategy. But the majority of us, come on, guys. We have good ideas.
A good 95% of the time, for $65 provisional, I think people should always file it to be safe.
Always.
I think it's smart. Now, a lot of you may have looked at patents in the past and you're like, this is all Greek to me. This is like some other language. You don't have to write a provisional patent like that. You can write it in common English.
Yeah.
And that's one thing I want to say. So if you're thinking out there, oh, I have to write a provisional like all those ones I read. No. It can be written in common English, which was the whole point of the provisional when the Patent Office came up with it, Stephen, because it was so that the layman could protect themselves. But then attorneys come up with this software and say, oh, we're going to teach you to write a provisional with claims and all this. Wow, mess.
Andrew, we should do a class on some of the things about a provisional patent application. We're not attorneys and we're not giving legal advice. No. We're giving business advice. But we can tell you, if you got an idea, file a provisional patent application. It's a great tool. And if you've got a big idea, maybe file a non-provisional later to see if there's interest. And maybe you get a company to pay for it. There you go. But by all means, educate yourself. And we'll still do more of these type of programs. And we'll dive in to some of the little details that probably people want.
Yeah.
There you go.
Thank you, everyone, for watching another inventRight.com TV show. If you like this, click on the thumbs up button down below. Give us a thumbs up. Also, if you go down below, we have a companies looking for ideas database with 1,400 companies looking for ideas. Totally 100% free. Check it out. You'll love it. And we'll catch up with you on the next inventRight.com TV show. Right, Steve?
You bet. Thank you, Andrew.
All right. See you, everybody. Take care. Keep inventing. Bye-bye.